as things stand, there is no review application. We are therefore saying there is no bar preventing accused 1, 3, and 4 from proceeding with the application for the amendment of the bail condition. To say they will file the papers later today is tantamount to moving the goalpost and not allow the accused to have access to courts and have the proper redress. So we are saying, Your Worship, there are no grounds for the state to now resist and have the application in terms of Section 63 adjourned. It's simply not whatsoever.
Let me on this, Mr. Khumalo. For who was the Recusal appeal on the 15th of October? Recusal appeal, do you know for who was the appeal?
The Advocate General was instructed by our office.
Yeah, she had appealed for accused number 1, 3, and 4.
Can I get the application?
She appealed for accused number 1, 3, and 4.
Yes,
yeah.
That's correct.
And then on the 15th of October, she made an application that the Section 63 application should proceed. And I ruled against it. I made a rule on the 15th of October.
Yes, we are saying, Your Worship, we are saying that ruling to grant postponement does not per se itself prevent the accused from now today to bring it to the court's attention that the reasons which the court granted the postponement are reasons that are non-existent at all, and the accused are entitled in terms of the Constitution, specifically Section 34.
My ruling was the Section 63 application cannot proceed until the outcome of the review application.
But there's no review pending, Your Worship. So what outcome?
Mr. Zumina, did you not file the review papers on the 15th of October?
It was filed on the 15th of October.
Your Worship,
I'm still on my feet. I'm still on my feet, and I do not appreciate the fact that Nelson refers to me being not honest with the court. When I'm addressing the court, when he's addressing the court, I sit down and respect him.
I agree.
Should do the same. Your Worship, we filed our documents on the 15th of October, and on another email which was not responded to by Leonard Friends, we then, after filing, made a follow-up with the clerk of the court. And the clerk of the court handed to us a copy of the register dated 23 October 2010, showing the High Court that the matter is being referred or filed with the High Court. That email we then sent to Leonard Friend on 23 October, attaching the copy of proof of the fact that the matter has been filed with him. And we did not receive the response again from Leonard Friend. I sent it to him on 2 or 3 occasions. Therefore, I do not understand what Leonard Friend refers to as the review application has not been filed. It has been filed on the 15th of October, and we even sent them with, firstly, with our notice of motion, and secondly, with proof that the clerk of the court has already filed a matter to the High Court. But, Your Worship, as the court indicated earlier, we will file all the documents with the court, and again that we file for a safe and effective. But, Your Worship, on the issue of the review application, the other friend is mixing up issues. The magistrate, Mr. Matani, who was dealing with the Section 63 amendment, recused himself in the middle of the application. And that is his decision to recuse himself is what the state took on review, since proper principles for recusal were not applied. And therefore, for their friend to say they want to bring another application before a different magistrate, whilst the review application is pending on an issue, is going to have 2 proceedings running parallel for the same issue, and that is not correct.
Your Worship, it's simple. All that the state has to do is to provide us with copies of the files issued and served out of the High Court. All that they are saying is that they've given us a copy.
Are you talking about the review?
Yeah, I'm talking about the review.
And I can undertake from Mr. Zumina that will be said today.
But that is not the point, Your Worship.
Yes,
the point is, as things stand now, there is no review pending. If they are saying there's a review pending, then they must provide the review to the courts. And only then we can then deal with the matter going forward. If they are saying they are going to give an undertaking to provide the review, that is not the question. The question is, as things stand, if we go to the records in the High Court, will we find this review pending? And the simple answer to the question is is no. And in the absence of that review application, there is nothing that prevents the accused from proceeding with the Section 63 application.
It's right.
That is,
I want that to show thing. Mr. Junior, is there proof of that is the indemnity proof?
There is, Your Worship, already there's a High Court case number, and that's, and I said earlier, we sent proof of that also to the FM, and we did not respond, we did not get response. We have a High Court case number 25/25 relating to the review application.
And what did Mr. Owen?
Your Worship, again, we shouldn't be told of a case number. All that needs to be provided is a record. And I'm saying, Your Worship, we don't have that record.
But he's an officer of the court. There's no way he can mislead me. I accept it that as a indemnity.
I'm not saying that he can mislead the court, but I'm saying, in light of our engagements with the state, it would have been easy when we engage them for them to provide us a copy of the issued paper. At the very least, he must satisfy the applicant that he has issued the papers, irrespective of whether those papers are issued irregularly. But if we are contending that there is no review application pending before the High Court, at least there is a duty for him to act in good faith and provide us that court case number as well as proof that the papers have been issued.
He has undertaken to provide.
If the matter can then stand down on those basis.
It's fine. The matter will stand down.
I'm sorry that I jumped up because I'm really busy. Can I respectfully ask that, given what I've placed on record, it is a very simple solution. The state has provided us now with the High Court case number. Surely, if they serve on us the papers, as they indicate that they will, there cannot be any prejudice to stand down and wait until tomorrow or whenever. So in the light thereof, unless my friend wants to press the matter of that it was irregularly issued, which it probably is by the sound of it, the clerk of the court in the magistrate court doesn't issue a review application in terms of 53. He's right about what he's saying. But if he wants to press the issue regarding his right to move an amendment of the bail conditions on behalf of his clients, that is a separate argument which my client is not a party to. And so, with the greatest respect, can I, as counsel for accused number 5, with respect, be excused by instructing the attorney is here that if the matter takes further time for whatever reason, that I don't waste the necessary court time myself. I'm a busy person, so with the greatest respect, with your permission, will you provisionally excuse me? My instructing attorney is present, so that if the matter is then later postponed, which it surely will be, he can confirm the date that is suitable to his time, and that is, of course, if it's suitable to my friends as well.
No problem, Mr. Pisturas, you are excused.
I'm debit to the court. Thank you very much. We will obviously agree to the postponement date, whatever it is, that's to be agreed. We are not going to involve ourselves in the other, let's call it, side issues. That's a good thing.
Excused.
Thank you, sir.
Matter will stand down. Call to the agenda.
All the rest of the lang, Dumisani. Stand down. Stand down.
Oh, it's a little
I'm not